meeting. Oh, just did that, so that folks who aren't able to be here are able to get this information after the fact, but just keep that in mind. We also wanted to let people know about a couple of upcoming workshops we have next week. They're in collaboration with the City of Buffalo's inspection department around this proactive rental inspection program that's just begun this year. And this is targeted at singles and doubles that are owned by investor landlords. So folks who aren't living in the properties but own these properties, singles and doubles. They've never had to be inspected before necessarily. So this is a big win for tenants ultimately in the city to be able to ensure that those properties are up to code for them. But it's going to have some impacts on landlords and tenants. So we're having these informational sessions next week to try to get the word out about that and how both of those groups can prepare for those inspections. Today we have a great group of speakers joining us. They have many years of combined experience on these issues, and so we're really appreciative that you all are able to be here and speak with us. So we'll go through and introduce all of our presenters here. So we have Adam Bojak, who's a Buffalo-based attorney, focuses on housing and tenant rights. We have Grace Andriette, who is the deputy director and supervising attorney of the housing unit at Neighborhood Legal Services. We have Sue Lumadue, who's the Senior Human Services Planner in the Department of Community Services, City of Buffalo. We also have Teresa Watson, who is the Housing Justice Organizer at Push Buffalo, and Sumathy Kumar, who is the campaign organizer for Housing Justice for All. So thank you all again for being here with us today. And then just really quickly, we'll go through the agenda and then we can jump right in. So our first section here is going through where are we now, the state of the moratorium in New York State, but also how that's changed over time, as well as talking about housing court, how it's happening on the ground as far as evictions, as well as what tenants should do if they receive eviction papers. So that'll be Adam and Grace talking about those issues. Then we will talk about the emergency rental assistance program, which Sue will be going through the nuts and bolts of how that all works. I know some of you in the attendees here might already have experience with that. And we'll have a question and discussion session here, just kind of as a note throughout. If you have clarifying questions, please put them in the chat. We have a couple of other folks here from PPG, Tom Vierpier and Colleen Christich, who will be helping to monitor the chat and raise up your questions if they're ones that can easily be answered during the presentations. But then we'll also have these larger question and discussion sections. So if you have overarching questions or ones that you think need a bit more discussion, wait for those sections to get into those. So after we have that first section there, then we'll have the from Teresa and Sumathy information on policy changes that we still need at the local and state level and how those are going, and then another shorter question and discussion section on those. So that is our agenda, and with that, I think I will pass it off to Adam for our first info little section here.
Yeah, thank you so much, Sarah. Hello, everybody. My name is Adam Bojak. I use he, him pronouns, and I am a local housing / tenants rights attorney here in Western New York. And so what I'm going to kind of do is just say, how do we get to where we are right now, right? COVID showed up in March 2020, but we're now a touch over a year and a half after that. So what has happened? How have we gotten to where we are right now? So I've put together a nice little chronological thing here. So, the simple truth is that housing was already in pretty bad shape. We already had an eviction problem, especially here in Western New York inside the city of Buffalo. And COVID just exacerbated already existing conditions in our housing markets. And so once COVID showed up in March of 2020, everything shut down, as we are all painfully aware. And so for a while, Governor Cuomo was basically legislating through executive order. He would put out new ones every single day, making sure that everything was the way that, whatever his experts were telling him. And so he was doing, he had in place an eviction moratorium by executive order. And he would always kind of wait until the last second to extend it further and extend it further. And that was kind of through last summer and everything. And then last fall, things got worse again. And so finally, the New York legislature said, well, we need to start to act and do something about this and put something in place rather than relying on executive orders. So in December of last year, they did the COVID-19 Emergency Eviction and Foreclosure Prevention Act of 2020. And so when it began, it said there will be no evictions until May 1st, 2021. And it also put in place the hardship declarations. And this is something that the landlord had to serve upon a tenant if they were trying to proceed with an eviction or had, they're going to court or anything. And the hardship declaration, once completed by the tenant, automatically froze any sort of eviction. They couldn't, proceed in court. And so then at the same time, there was federal legislation as well. So the CARES Act was right at the beginning in late March of 2020. And that came with, New York, this was less important in New York because we already had pretty strong protections here, but this was what they did for any gaps nationwide, states that didn't do anything. So, the CARES Act came with a 120-day moratorium. And then later on, the CDC, and that was in September of last year, they put a moratorium in place that would last until December. And just like everything else, they extended it into the next month and then later and then later. So they kept it in place because things got bad, like I said, last fall, and they didn't really get much better. They kept going, down and then back up as far as cases and deaths nationwide. The pandemic never really ended, of course. And so over time, as I said, these things continue to be extended. And the ones that we had here in New York, of course, they continued to extend those as well. And then naturally, there's going to be pushback from the real estate interests here in New York, as well as nationwide. So these things were taken to court, as they always are. New laws rarely go without challenge in court. So the money behind real estate interests said, well, we don't think these should be allowed. And this August, just last month, is when everything kind of fell apart as far as these moratoria. So the Supreme Court of the United States ruled that the New York's the section of that law from last year was unconstitutional because it violated due process. Having a tenant say, yes, I could not pay my rent because of COVID-19, having that automatically freeze the eviction proceedings and block the landlord's access to court was, in that court's opinion, a violation of due process. They said, a person cannot be a judge in their own case. And then they also, in the same month, struck down the CDC moratorium, just saying that this exceeded the CDC's authority. And though both of those were unsigned opinions, which is always an eyebrow-raising thing as far as the Supreme Court is concerned, but neither of these decisions were very surprising based on the makeup of the Supreme Court. And so here in New York, we responded to that very quickly. Governor Hochul, just earlier this month signed a new package into law. It says that the hardship declaration is still part of it. We can still, we're extending all that coverage, and we're still having the hardship declaration be a part of the process, but the landlord can now request a hearing. And so, it kind of takes care of that due process issue in the previous iteration, saying that if somebody says they cannot pay because of a hardship, at least we're not going to have a hearing on that, rather than just automatically having it freeze out of it, right? And then the final thing that's been going on at the same time, I won't go too much into this because we're going to touch on it later, is the Emergency Rental Assistance Program, known as ERAP, which is a bunch of billions of dollars that Congress put aside nationwide to help renters pay money. Now, New York has had their issues. At the time that the Supreme Court handed down that decision, we had only paid out about $100 million of what was put aside, which is less than 4% of the funds. Now, I will say, since Governor Hochul took over, that has definitely sped up a bit, but we're quickly running out, and there are still many more that have not applied or haven't even gotten responses. So that is kind of where everything stands right now. A lot has been put into place and then taken back or just expired. And so now Grace is going to take it from here and kind of say, what does the process look like right now? And where do we expect everything to go moving forward? So I thank everybody for having me today, and take it away, Grace.
Adam. So thanks to all of you for joining today. I used to joke that, once you knew landlord tenant law, you were in really good shape because landlord tenant law never changed. And like for decades, the law really stayed pretty much the same. And then everything changed with the pandemic. So as you heard from Adam, it's kind of a confusing array of new laws and new protections, which are excellent, but are also a little confusing. So I'm going to share my screen. I'm going to just start, if I can get to my screen share. 1 second. Sorry about that. Doesn't it figure that whenever you want to make things work, they don't want to?
We could see it there, Grace, for a second, and then it went away.
Yeah, and then it disappeared. Hold on 1 second, and let me see if I can get this to work from beginning. All right. So I can't find my first slide, but it's okay. We'll start with the second. So if there's anything that you take away from this, I've just included it in the first slide, and then we'll get into the weeds, right? So what I'm going to talk about is eviction court, what's going on now, and how does the hardship declaration that Adam referred to, and also the emergency rental assistance program protect tenants. So just 3 things, if you don't remember anything, remember these. First, people should never ignore court papers, right? So there's a lot of court papers being sent out right now, a lot of demands for rent, a lot of letters from landlords saying you violated your lease. People shouldn't ignore court papers. What everyone should know is that right now there's free legal assistance and also assistance in applying for, I'm going to call it ERAP, available in Buffalo City Court. Buffalo City Court is hearing eviction cases 5 days a week, which isn't different from how it used to be pre-COVID. What is different is they're hearing cases both morning and afternoon. And it's not really that more cases are being heard right now. It's just that they're trying to be respectful of social distancing concerns. And so people are scheduled at different points throughout the day. And if you're working with a tenant who's facing eviction, if they're going to city court, as I mentioned, free legal assistance in Buffalo City Court every time evictions are being heard. In courts outside the city of Buffalo, tenants can get legal assistance, free legal assistance, and also assistance with ERAP applications by calling Neighborhood Legal Services, the Volunteer Lawyers Project, the Legal Aid Bureau, and or the Center for Elder Law and Justice. And so the numbers are included on those slides. Okay, so 2 more really important pieces of information. If a tenant fills out an ERAP application, generally, and I'll get into the weeds in a second, the landlord won't be able to proceed with an eviction. It's called a stay. It just means that the eviction can't move forward until there's a determination that the tenant is eligible or ineligible for ERAP. If the tenant is eligible for ERAP, and we'll talk about this for a moment, those protections should go forward. If they're not considered eligible, there's always the second protection, and that's the eviction moratorium that Adam referred to. The governor extended those protections until January 15th. So whether or not someone fills out an ERAP application, if they've been impacted by COVID in any way, and I'll show you what that hardship declaration looks like at the end, then their eviction should be put off until January 15th. So filling out an ERAP application stops or puts off an eviction until there's a determination of eligibility and likely beyond. But whether or not you apply for ERAP or not, if you were impacted in some way by COVID, your eviction will be put off until January 15th of 2020. What's going on right now in city court is that some cases are being adjourned or put off for what's called a status conference. So it could be that the court wants to give the tenant an opportunity to apply for ERAP, and they want the landlord and the tenant to check back in after that's been done. It could be that the landlord is saying, I don't believe that the tenant actually suffered a hardship, although we're not really seeing many situations where that's happening. Or it could be that the tenant was denied ERAP, but again, unfortunately, the process is moving slowly, so we haven't seen, fortunately, many denials, and that really hasn't been an impact so far. So let's get into the weeds a little bit. As Adam mentioned, the Supreme Court weighed in and said, not fair to landlords. Tenants can say they were impacted by COVID and the landlord can't do anything about it, and the case is put off. So what's the same as before the Supreme Court case, although the date has changed, is that if there's an ongoing eviction case and the tenant previously filed a hardship declaration, that case is generally going to be put off until January 15th. If landlords are filing new eviction cases, they have to include an affidavit that the tenant was provided with a copy of the hardship declaration, and the hardship declaration has to be provided either in English or if the tenant's primary language is not English, then it has to be provided in the tenant's primary language. The landlord also has to say that neither the tenant or the occupant has returned a completed hardship declaration. So that's just the steps that a landlord has to go through before they can file an eviction. So there's exceptions to this hardship declaration protection. So, basically if the tenant says, I've been impacted by COVID and the landlord is bringing an eviction, everything is put off until January 15th of next year. But exceptions to the rule. If the landlord alleges and can prove that the tenant is intentionally causing significant damage to the property, the tenant is breaking windows, says the landlord, then that hardship declaration isn't going to protect the tenant. If the landlord says the tenant is, and I should put the language in here because I want to give you some examples of how we can play lawyer on this, but we'll do that in a second. So if the landlord is saying the tenant is persistently and unreasonably engaging in behavior that infringes on the rights of other tenants, then that could be a reason for the tenant not to be protected. Or if the tenant is causing a substantial safety hazard to others. So you can imagine that there are a lot of behaviors or alleged behaviors that would fall under this category. But let's say the tenant simply wakes up every morning and curses out the landlord in front of the property. So I'm looking at this and I'm thinking, can I defend the tenant? Can I raise a legal argument? Well, they're not causing damage to the property. They're not bothering other tenants, and they're not really causing a safety hazard to others, as long as my client's not threatening anyone. So I think we haven't been put in this position yet, but I think that we as tenants advocates can make arguments that this sort of exception to the hardship declaration doesn't apply in many situations. Or we could just say what you're alleging, landlord, is simply not true. But even in situations where the landlord can come in with some sort of proof, I think the fact that these exceptions are pretty specifically defined, both broadly and specifically, mean that we might be able to make arguments to keep tenants housed. So if landlord feels that the tenant is engaging in any of these behaviors, the landlord has to provide a specific description. So the landlord can't just say, the tenant is a nuisance. That's pretty vague in general. The landlord really has to give the how, when, and where. So on, September 5th, I saw the tenant smashing windows with a baseball bat, as did my witness who's here in court with me. Actually, that doesn't have to be provided in the description, but once you get to a hearing, the landlord would have to substantiate their claims. The landlord, Adam referred to the fact that the Supreme Court didn't like the fact that landlords couldn't challenge these hardship declarations. So the tenant might say, I've been impacted by COVID, either financially or for a health-related reason. And the court felt that it was unfair that the landlord didn't have an opportunity to challenge that. So now they do. That's what's changed recently. And the landlord has to indicate that they have a good faith basis to believe that what the tenant said is not true. So the landlord has to come in with proof of this, and the tenant has an opportunity to refute that. So if the tenant lost their job, for example, if the tenant has a medical condition, that's all evidence that could be presented in court. As tenants advocates, we're concerned about the level of medical proof that a tenant might have to prove in court. If I'm suffering from a disease that impacts my immune system, maybe I don't want to go into a courtroom and talk about that. We would argue that if you have a note from a medical provider that indicates that you're a person who has a health condition that could be negatively impacted by COVID, that would be sufficient. To be honest, though, we haven't seen those challenges yet. We hear landlords consistently say in court, "Oh, we don't believe that," or "We're going to challenge that." But actually, the judge in Buffalo City Court has been cautioning landlords that if they want to challenge hardship declarations, they're going to have a pretty big fight ahead of them. And so, as far as we've seen so far, most landlords are dissuaded from challenging hardship declarations at this point. They're probably also waiting for that ERAP money to come through, so we'll see. If the landlord does say that they don't believe what's written in the hardship declaration, if they're challenging it, then, as I mentioned, the court has to have a hearing. And if the court decides that the tenant has been impacted by COVID, then everything is put off until January 15th. So one of the other ways that tenants can be protected from eviction is by applying for ERAP assistance. And so applying for ERAP will generally put off an eviction until there's a determination that the person's eligible, or hopefully not, but ineligible. There's those same exceptions that we just talked about before that apply to the hardship declaration. So if the tenant is damaging the property, if they're bothering other tenants or occupants, or if they're causing a hazard to others in some way through their behavior, then the ERAP application is not going to protect the tenant, and the tenant could be evicted. So if landlord, or when a landlord accepts ERAP money, the landlord also has to agree to several things. The first is that the landlord has to agree that the ERAP payments cover the full amount, the full rent for the time covered by the payment. Let me say that a little more clearly. So if ERAP is going to pay for rent for March, April, and May, the landlord has to agree that that payment covers all of the rent that's due for March, April, and May, and can't come back later and say, no, actually they gave me 500 and the rent was 700. So if you, as a landlord, accept rent for a certain period, then you can't in some other place try to collect that rent from the tenant. If the landlord's been charging late fees, then the acceptance of the ERAP monies means that the landlord is giving up their claim for any late fees. The landlord also has to agree that the rent will not be increased for 1 year from the day that they received the ERAP payments. And we look at the amount of rent that was charged or received for ERAP as an indicator of what the rent was. And then the landlord has to agree that there won't be any evictions based on holdover or expired leases for 1 year from the receipt of the payments. Now, there's some exceptions to that. So no eviction for 1 year unless other rent is or becomes due and unpaid. So let's sort of figure out a scenario here. Let's say I owe 15 months of rent, and I think Sue is going to get into the ERAP, what the ERAP program provides next. So hope I'm not covering too much of your material here, Sue. But let's say the tenant gets 12 months of ERAP assistance, but actually they owe 15 months. The landlord could say, well, I got 12 months, but what about those other 3 months that are still due? Well, that's a situation where the eviction moratorium is going to come in to protect the tenant from eviction until January 15th. And that gives the tenant an opportunity to maybe enter into a repayment plan with the landlord, or to apply for other money, so maybe from the Department of Social Services, to fill that gap. If the tenant stops paying rent, though, and Sue's going to talk about the fact that people can apply for back rent and forward rent, but let's just say the tenant stops paying rent, the landlord could bring an eviction action. But again, if the tenant filled out a hardship declaration, they should be covered until January 15th. There's another exception to this ERAP protection, And that's in a situation where a tenant lives in a building with 4 or less units, and the owner of the building or the owner's immediate family intends to immediately occupy the unit as a primary residence. We haven't seen that yet. You know, if we do see that, I think we are going to be looking to verify that someone in the owner's family is actually moving in, and we'll probably continue to make sure that happened after the court rules against our client, if that were to occur. We haven't seen it yet, but it is written into the law. And again,
sorry, do you mind if you wrap it up in like 30 seconds and then we could continue?
I'm so sorry, I didn't.
No. There's so much to cover.
Yep. Again, if the landlord's damaging property, bothering other tenants, not so good. If the landlord won't accept ERAP, and Sue will probably get into this more, the tenant is protected and the state will hold on to that money for 180 days. If the landlord refuses to accept ERAP or changes the tenancy, the tenant may have a claim based on source of income discrimination, or the tenant may have a claim based on other protected classes, based on their race, their familial status, sexual orientation, and so forth. More slides, we can get to them. Just reminding you that Neighborhood Legal Services provides assistance in eviction, housing discrimination cases, and we help with ERAP applications. If you want more information about ERAP, the OTW website is great. The New York State Hardship Declaration is available at this link, and I can send everyone my slides. And if you're not sure who can help, call 211. Thanks, everyone.
Thank you so much. And sorry again, I know there's so much to cover. It's so hard to fit it all in, but hopefully folks will have questions too that can kind of. All right, so up next we have Sue talking about ERAP. So I'm going to spotlight you, Sue, and then I'm going to share your slides.
Thank you, Sarah.
Present, share screen. Okay, yes, and just let me know when we're switching from one to the next.
Okay, great. Thank you. Thank you for having me today and for inviting me. You know, this is such an important program, and it's probably the most liberal and generous program, you know, that we've seen in terms of rental assistance in a long time. Normally, the city of Buffalo has about $75,000 a year to help prevent homelessness. And this year, we're using our $18 million allocation from the United States Treasury, and we've joined with New York State OTW, and we have access to their $2.4 billion. So a very wise and strategic decision was made early on, just so that because we knew the need would be far greater than we even anticipated. Next slide, please. So again, the ERAP program funded by the Consolidated Appropriations Act and the HEROES Act, $25 billion in rental assistance across the country. It has, as Adam said, it has been the subject of a lot of disgruntled landlords, and there's certainly been a lot of conversation about the ability to roll the program out, but it has now rolled out and it really is actually getting to residents. So in terms of the city of Buffalo, any resident is eligible to apply for ERAP if they meet all of the following criteria. So initially, when they rolled it out, household income was at 80% of the median income. And a couple of weeks ago, they announced that they now have $125 million set aside to be able to serve tenants with income up to 120% of the area median income. So that's a new program, that's a new effort. It's on a first come, first served basis, and it probably won't last long. But, you know, just to let everybody know that 120% of the median is a $52,224 annual income. So it certainly broadens the eligibility. Next slide, please. So another piece of eligibility is that the applicant has to be obligated to pay rent at their primary residence and that they have rental arrears for rent owed after March 13th of 2020. The household must be at risk of experiencing homelessness or housing instability. The way to demonstrate that is if you have rental arrears, you are at risk of housing instability. So it's important that people know that this program is really open to anybody who has arrears. Next slide, please. You know, there are no immigration status requirements to qualify this program. There is no requirement to give a social security number. It is a part of the application. However, people are not rejected because they don't provide it. And an important thing to note is that this is a rental assistance program that if you have a rental arrear, you can also get help with your utility arrears. If you have a utility arrear alone, you can't get help. But if you couldn't pay rent and you also couldn't pay your utilities, you are certainly eligible for the program. Next slide, please. So the benefits of this program are up to 12 months of rental payment arrears for any rents accrued after March of 2020. If you are paying more than 30% of your gross monthly income for your rent, you could apply for up to 3 months of additional rental assistance. So that's really important. This is going to help people looking back, and it's certainly going to help a lot of people going forward. And it certainly presses the proverbial economic reset button for many households in the city of Buffalo throughout the nation. And if you have those rental arrears, you can also apply for up to 12 months of electric or gas utility arrear payments. So again, you can't apply for utilities alone, but if you have rent that you're owed and you have utilities owed, you can certainly apply for both of them. And we really encourage everybody to apply for that 3 months of forward rent. Next slide, please. Thank you. The OTDA has done a really good job of, it took them a long time to get the online portal up and running, but they've done a great job of being flexible and kind of responding to changes. The U.S. Treasury is trying to make it much simpler for people to apply, and there's been an increase in the amount of applications they've received for these programs as a result of making it easier. So renter applicants will need their personal identification. They're going to need something that proves where they live, so a utility bill or even their lease, or if they can't have that, they could certainly have a note from their landlord indicating that they are an occupant at this place. They need proof of rental amount, what rent are they supposed to pay, and they'll also need proof of rental arrears. Again, it could be as simple as a notice from their landlord letting them know they're behind X number of months on rent and they owe X number of dollars. They do need to prove their income. So that could be their 2020 taxes or any income pay stubs for the last month. Could also be a bank statement showing a direct deposit. If they're applying for gas and utility assistance, they'll also need to provide a copy of their gas or electric bill, which shows that they are behind in those payments. And then they're going to need to attest to a hardship due to COVID. And when this first kind of started, this whole COVID hardship, there was kind of consensus around the fact that people had to have lost income or they had to have impacted by COVID. And when you look at the OTDA website, and I encourage everybody to go there, you will see that there are many, many reasons that they are accepting as a hardship due to COVID. So again, schools weren't in session and you couldn't send your child to school, you couldn't work, that's a COVID hardship. But let's just say a tenant, and Grace had called me on this early on in the pandemic. We have a tenant who paid their bill with a credit card and now they're at risk and they can't pay the credit card bill, but they're okay on rent. Even OTDA has said, yes, now we can accept those clients or those tenants who paid bills with credit cards and can't afford the credit cards. We can accept that as a COVID hardship. So again, they've been flexible and really just trying to embrace the idea that we want to get this rental assistance out to everybody. Next slide, please. Landlords can apply as well. So again, this is really a partnership. Grace showed you the slide early on that if a landlord refuses to accept, it doesn't necessarily mean that they're going to be able to evict that tenant because there's a 160-day waiting period. So I think that, 180 days. So I think it's important that landlords know they need to be partners with their tenants. And we have many landlords who are working very closely with their tenants to get these payments made. So they'll need to provide, they'll need to go onto the ERAP portal or get help from one of our assisting agencies that I'll talk about in a little bit. But they need to complete a W-9 form because the funds will be directly deposited into their bank account. They need to show either an executed lease or they need to show a canceled check, some kind of evidence that there was a payment for rent at some point during the period of use. They need to document the rent due. If they have a ledger, could be a notification, could be something very simple. OTDA is willing to accept those kind of non-formal forms. And then again, the banking information so they can receive the direct deposit. Next slide, please. You know, landlords just, again, they need to, as Grace kind of reviewed all of this, but, you know, they do need to acknowledge that this ERAP payment will satisfy their full rental obligations, that they won't evict the tenant, they won't increase the rent, and they're going to waive any late fees. It's very important that either the property owners or the authorized property management company create an account on the ERAP portal and then actually enter and upload their information. Next slide, please. There are a lot of helpful resources for tenants and landlords right on the website. And again, there's a lot of FAQs. There's a place for providers. There's a place for landlords. So, you know, again, if you have any questions, I think they've done a really good job of trying to capture all of the information. The OTDA website, again, I will put it in the chat when I'm done speaking. But not only have they created this kind of robust website, but they've got a call center where anybody could call if you need help, if you got stuck completing the application. And that number is 1-844 New York 1 rent. I'll put that in the chat box as well. Next slide, please. And again, anybody who is ready to apply, you can do that obviously 24 hours a day, 7 days a week online. We just need to remind people that if you're going to start an application, there was a point in time when you couldn't finish an application, but at this point, if you start an application for yourself, for one of your clients, make sure that you write down the account number when they create the account on the ERAP portal. And then if you're going to be trying to check on behalf of the client, the tenant, make sure that you have their date of birth, because you can start an application, you can log out, and then you can log back in with that account number and with that date of birth. That's also how you'll go in and check the status of your application. So tenants, application assisters, anybody can really kind of help do that. So again, it's really important that that happens. I want to let everybody know too that, again, going online and uploading documents isn't for everybody. So we've really created, the city of Buffalo has created a really robust partnership of 17 organizations speaking multiple languages, who are more than willing to make an appointment with a tenant, go through the process, help them with the application. They're also helping landlords to be able to do the applications. Many of our city of Buffalo landlords are small landlords. Maybe, you know, maybe they just need somebody to kind of walk them through the instructions. So, and the way to access that is really the simplest thing to remember. Just dial 211. If you call 211, you let them know that you need assistance with the ERAP application as a landlord or a tenant. They're going to let you know who the available partners are. Hopefully we can find one close to your house or close to the tenant's house, place of work, so that it's not inconvenient. We've tried to be as robust and as understanding as possible and removing all barriers to making this program work. It usually takes about, it has taken about 8 weeks for applications to be paid from beginning to payment. But I will tell you that currently right now, the city of Buffalo has over 7,000 applicants in the system. So 7,000 tenants have applied. OTDA has made 1,061 payments to the tune of about $5 million. So the average amount is about close to $5,000. And more than half of those people have applied for prospective rent. So they're not only getting their rents paid, but they're also getting that forward rent as well. And when you look at the data, and again, on that website, the OTDA website, you can actually see who are the clients that are getting served. And when I looked yesterday, you know, I was not surprised that the majority of applicants are those people at 30% of the median income or lower. So again, this assistance is getting to the people who really need it and the people who have been severely impacted by COVID. Next slide, please. Or is that all I got?
That looks like the last one, yeah.
Okay. And I'm happy to answer any questions in the Q&A.
Perfect. All right. Well, thank you so much, Sue. Let me stop this, remove spotlight here. Okay. So we are in, oh, perfect. We already have a question here to clarify a case or client to explain it through audio. Yes, please. Yeah. And yeah, Ben, feel free to unmute, explain the question. And also anybody else who has questions after, feel free to unmute and ask questions that way as well. Do you want to unmute? Let's see if I can find you here. I might be able to do it. It looks like you're unmuted, but we're not able to hear you. Oh, not muted.
Hello?
Oh, yep, I hear a little hello. If you maybe speak a little bit louder, I think we'll be able to hear.
Can I hear me?
Oh, it's very quiet. So quiet.
Oh, sorry. Oh, I don't know what reason. It's what about now? Can you hear me?
I can hear you. I don't know. Are other folks able to hear okay? Okay, so. Okay, let's try this.
Okay. I'll try my best. Okay. So I have a client. Actually, he applied. He came to me several times. He tried to convince the tenants in order to come here and apply for this program, but she refused. And he doesn't have an income right now, and he lost, for more than 1 year, the income for the rent because he doesn't have a lease agreement. And actually, I applied to him through this website, and I upload all the required documentation. And I talked with his lawyer. He said that he couldn't submit any case in the court unless he has a paperwork. So could he take those paperwork to ERAP and submit them to the court in order to protect his rights and get his late rent or arrears? What could he do?
I heard the big strokes there. Sue, you unmuted. Maybe I heard, tell me if this is right here, that there was maybe some questionable contact with the landlord, maybe you couldn't get in touch with the landlord. There's no lease, it sounded like. And there's a question about uploading paperwork. Maybe if anybody has, I see some shaking heads from the folks who are.
Question is about a landlord whose tenant isn't cooperating, but I may have that incorrect.
Yes, the tenant is in, yeah.
Oh, we can hear you now.
Yeah, the tenant doesn't cooperate with the landlord.
Okay. So let me tell you about something that is coming, and you're going to need to keep your eyes out for it. But OTDA has set aside another chunk of funds, not ready to release it yet, but it's $250 million for landlords who did not get cooperation from their tenants. So again, it will be coming. It will be an online application. You can get assistance from 211. The priority will be small landlords for the first 30 days, and then it will open up to larger landlords. So small landlords being those who have 20 units or less. So when we get to that opening, we would love to be able to get in touch with you and let you know that that program is open, because it's also first come, first serve. And the way for us to get in touch with you is if you would call 211, you could register for the Landlord Hardship Program. And then when the program opens, 211 will send you an email or a text message letting you know it's time to apply. Does that help you?
Yes, so what I understood is that there is another program related with the landlords. It's called the Landlords Hardship Program, right?
Right, Landlord Hardship Fund.
Yeah, so it's different from this one, right?
Well, it's a part of this. What I believe that
New York State somehow, yeah.
Yeah, they realized, and we've heard it. There are some tenants who don't comply and they're avoiding their landlords and they don't want to apply. So OTDA has heard that. They've set aside a source of funds. They're going to be paying it. Again, it's first come, first serve. So as soon as you get that email or that text from 211, after you call them and register, make sure you get on quickly and do that application. And if you need help with that application, 211 can provide you a helper.
Okay, good. I have another question, please, regarding another client. Actually, she's an old lady. She doesn't have any source of income. She's like over 80 years old, and she's afraid from going and to a nursing home because of the COVID. And now she lives with her daughter, but you know her husband, he pays her the rent, and now she's late. She received SSI and food stamps, but no other services. And this doesn't cover the rent and her own expenses. And when they come to me, actually I applied to them, but till now, I mean, I think the case is still pending. So it's somehow related with the COVID, but not 100%, you know. But they're afraid, they're scared, a little bit scared and afraid from the, from the COVID-19, and they don't want her to, to live with the in a nursing home. So I don't know about the eligibility of this case.
So, again, if she is behind in rent, then I would encourage her to go on and apply. OTDA will make the determination whether they consider the desire not to go into a nursing home a COVID hardship. But again, they've been very liberal and generous in their definition. And I don't think that that's going to change anytime soon. So you have nothing to lose by certainly going on and assisting with an application.
Yep. Okay. Very good. Thank you very much. I appreciate it.
You're welcome. Good luck.
Other questions about, the ERAP program, how things are working in court, what tenants should be doing, anything like that? Again, you can feel free to unmute and ask your question directly or type it into the chat.
Sarah, I'm sorry. If I could just add one thing again, I just really, I just spoke about that landlord hardship program. So if any of the folks who are listening in have come into contact with landlords who are very frustrated and upset, have them call 211, register with 211 so we can get the information to you as soon as that portal opens up. Thank you.
That's really helpful to know. Yeah, other questions or even, comments on, clients you've been working with and how their experience of all this has been going. Yeah, anything, feel free to share. No questions? You all must be experts because I just I have 10 questions, but
we did that good of a job. That's okay.
Yeah,
right.
All right. Well, I don't want to cut anybody off, but I guess we'll move into our kind of policy question here, and we'll have another kind of question discussion section there. So if something comes to you that pertain to this first section, feel free to ask it then. Oh, here we have a question. It sounds like section 8 tenants apply.
Yes, they can. So they can't apply for more than their portion of the rent, unless for some reason they got thrown off, the tenant got thrown off the Section 8 program. Obviously, if the landlord didn't receive a housing choice voucher because the landlord hadn't made necessary repairs or there was some other reason, then the landlord wouldn't be entitled to that rent payment. But tenants who receive a housing choice voucher could apply. They're probably not real high on the priority list, Sue, but but they should certainly, OTDA, Office of Temporary and Disability Assistance, who the agency that is managing these funds, they did set priorities about like sort of who could apply in the first wave, the second wave. But I think the guidance is just apply, and as Sue said before, there's no downside to applying, and people should really apply for this money, and hopefully will be found eligible.
I have a question. So as far as, it seems like ERAP there is a finite amount of money allocated to Buffalo. Have you heard of plans at the state or federal level to potentially expand that once presumably it'll, be gone at some point?
Yeah, New York State said in a call that we were on with them last week that they're not concerned. They're going to be seeking additional money once they get through their $2.4 billion. And, I don't know where the infrastructure bill is right now, but I believe that there is additional requests for rental assistance at all levels of government. So again, just want to keep everybody whole and housed.
Looks like Teresa has a question here. If a landlord declines to accept ERAP or doesn't complete their end of the paperwork, can that be considered source of income discrimination?
Yes, so the answer to that is yes. It's pretty clear in the legislation that that's considered source of, or it could be considered a form of source of income discrimination. Basically source of income discrimination occurs when a landlord refuses to accept money from a source, right? Regardless of that source, as long as it's legal to pay the rent. So a landlord who refuses to accept ERAP money could be considered to be discriminating on that basis. A landlord who doesn't accept, let's say, a security agreement from the Department of Social Services, or a landlord who won't accept a housing choice voucher, a tenant who has housing choice voucher assistance would be considered to be engaging in source of income discrimination. So yes, the law is clear that a refusal to accept ERAP could be considered a form of source of income discrimination. Thanks for asking, Teresa.
Grace, would NLS be taking on potentially some of those cases? If people experience that, should they be contacting you?
Yes, we're prepared to take those cases, and we've been screening for source of income discrimination claims as well, especially when tenants tell us my landlord doesn't want the money, refuses to accept it.
Any other questions, comments?
I have one more, Sarah. Sorry about that. I do want to let everybody know that on October, I just want to double check my date. On October 21st, we will be having an application event at the Father Bell Center on the west side. That is the only one we confirm right now. But again, we're trying to set up events in communities, doing everything we can to be as robust as possible to reach everybody. So that will be from 2 to 6 p.m. at the Father Bell Center. If you have clients who you think could apply or might need some assistance, you could certainly direct them there. There will be application assisters there. So they can make the connection right then and there in the neighborhood. Thank you.
Excellent. All right, I don't see anybody else unmuting, but again, if you have a question that comes to mind as we kind of keep going here, please put it in the chat and we'll address it at some point. So at this point, we're moving from what exists currently to what some of us might want to see in the future. PPG has worked on a lot of different housing policy issues over the years and worked with PUSH quite a bit on those. So really interested to hear from Teresa what PUSH is working on now as far as tenants' rights, and to hear also how partners could potentially connect in that way if they are interested in trying to help move these policies forward. All right, sending it over to you, Teresa.
Thank you. Let me set up my screen share. So yeah, hi everybody, I'm Teresa. I am our housing justice organizer here at PUSH Buffalo. It's so exciting to be with y'all, to hear about, things that are existing, all of the amazing work that everybody is doing to try to keep people housed and safe and get the money out. I think there's so much important work that's happening, and we also know that there's so much work still to do. So we, of course, at PUSH, as the housing justice organizer, we do housing work. Our biggest local campaign right now is around a tenant bill of rights. A tenant bill of rights is I mean, I really love our Tenant Bill of Rights, actually, because it is a really comprehensive document that has 10 rights really built from feedback in community research. So it's very representative of the diversity of populations across the city, and their respective housing needs. And at the same time, it's all of these are very interconnected as rights, right? And so I think that the beauty of this document is it was created, it wasn't created by push, it was created in coalition with many other partners, and it was created really from like that community feedback. So it's really, for us, one step towards having a homes guarantee, and addressing many of the ongoing housing issues in Buffalo. So I know that Sumathy will get into good cause as a policy right after me. I will not spend a lot of time on this, but good cause eviction will essentially make it so that people cannot be exited from their homes without cause, right? They can't kick you out without a good cause. They can't kick you out just cause. And so I myself in the pandemic was given a 30-day notice. And I know, there's an eviction moratorium. I could have worked on it, whatever. She wanted to raise the rent. But it was just really interesting to see like how easily displaceable people really are for sort of no reason, right? And how we often see 30-day notices given to people as a retaliation for trying to get landlords to fix many of the habitability issues in their units. It's a story that we hear over and over and over again. So we know that this is a really important protection for tenants in the city. And goes right into timely repairs, right? So while this law exists on the books, it is, we know, not upheld as it needs to be. So we definitely uplift the proactive rental inspections plan. We think that that is a great beginning from the city council to start to understand some of the disrepair that our homes are in. But we also know that the housing stock in this city it has experienced generations of neglect, right? That we have had a slumlord problem in this city for so long that tenants are met with rent increases or those eviction notices when they try to demand just safe housing. Yesterday, I was seeing a friend of mine for the first time in a while, told me about her housing issues, and she said that she had recently moved into a place. The landlord ignored her for 3 months when she was talking about mouse repairs. And then when he finally came over to just put some plaster over some of the holes, he also tried to charge her for some scratches on the hardwood floor and like other cosmetic damage that some of which had existed there before she even moved in. And so there's really like a culture of retaliation that we need to be protecting people from at the same time as we're guaranteeing repairs. But then we also know that language access is a really, really important need. So our housing court does tend to give people translators by the time they're in front of a judge, but documentation is not represented like it needs to be. We are a beautiful city of so many diverse communities and different populations. And that needs to be understood and respected at the level to where, if somebody gets an eviction notice when there's not an eviction moratorium placed on their door, right? And we know that the eviction moratoriums aren't going to last forever. If it's in English and they speak Tagalog, they've essentially received no notice, right? And so there's a lot that needs to be done to enhance and integrate language access for folks. So this is, again, one of those things that needs to be impacted. I'll say the language access group, working group with Partnership for the Public Good, does really amazing work on this, and we have partnered with them to expand some of the language access options. But I would also say that, this is, again, part of our big campaign. We're pulling together a coalition of partners, and we would love to have folks join us on that. So, people who want to support any or all of these rights, please pop your info in the chat, and I will definitely be reaching out. And now this one, I love this right because it so intimately connects to the ERAP application. We hear from people all the time, I want to do my ERAP, but I only have a property manager who keeps saying that they're gonna send the information to the landlord, but I don't know who the landlord is and they haven't finished their end of the paperwork. And there's not currently a way for them to know who owns the building. We have a lot of people who hide behind LLCs, multiple different LLCs, and sometimes they have intermediate property managers. It's often used as a smokescreen to get out of accountability for repairs. We also hear, and I see Grace shaking or nodding her head, because I know that you all deal with this all the time. It's a great way for them to just avoid accountability. City Hall will straight up say that they do not have the resources to do all the research that it would take to figure out who's behind all of these individual LLCs quite often. And it's a way that people avoid accountability. So, I'm sure that a lot of people on this call could speak to it more. But we really, again, see this as so intricately tied to so many of the other rights. Legal counsel in Buffalo City Housing Court, I'm sure, Grace and many of the other people here know how imbalanced it can be if a tenant shows up to housing court without somebody behind them, if they don't know the processes. So this is another way that the systems are set up to really disempower people. And we just believe that everybody needs and deserves proper legal and housing court representation, right? We know that this is a way that the larger landlords, especially the developers who are driving up the rent costs in our city, are disempowering folks, people who may not know all of their rights around withholding rent, for example, often get bulldozed in court, which is why the right to housing stability is also so key. I will say that the eviction moratorium has, in a way, given people stability that many have not seen. Many people have not been able to stay stable in their same units like they have since the pandemic. And of course, we know that it still feels very tenuous every time. We're not sure the eviction moratorium is going to extend. It's very difficult for folks to be living in that uncertainty. And especially when ERAP applications aren't going through, the money hasn't come in, they're not sure if the property manager got the thing to the landlord, if the landlord actually filled it out, right? But the instability of renters is something that is so taken for granted. I talk to people all the time, and they don't expect to be able to stay anywhere. The moving costs that people incur every year, families having to change schools, children having to get used to new locations. It really is an incredible hardship. And it's also a way that our rents keep rising, right? Every time somebody moves, the landlord can hike the rent a bit more and hike the rent a bit more. Same thing with those 30-day notices. Again, this goes right back to good cause. So these are deeply interconnected rights that are just related to one of the most basic human rights, the right to shelter, right? Food, water, shelter. It's kind of your basic three. Now, the right to first refusal and right to return, I'm not going to go too deeply into because it's a little technical, but we know that gentrification has been decimating a lot of our beautiful communities across the city. People are getting pushed out to Niagara Falls and beyond, into the suburbs, beyond where they can really access public transportation to get to their jobs. It's very isolating. And so it's been a massive policy issue and a huge blind spot in Buffalo. Something that needs to be addressed. And there are policies to address it, right? Now, rent stabilization. this again intimately tied to that stability and the right to return. So I think many of you, if you're doing direct client work, you know that the rents are just going up and up and up and up and up. And they have increased something like, oh my gosh, like 30% in the last year, or some absurd statistic. That statistic might be wrong, but I know all of you are experiencing it in real time, right? You don't need a statistic to know that people can't find apartments that they can afford. And that the quality of our housing stock is not really improving as the costs go up. And so it's really distressing that people are still having to pay more and more and more money that we can't afford as the third poorest city of our size in the United States, for units that are still deeply uninhabitable.
Hey, Teresa, and I still have a couple more if you're able to move through them a little.
Real quick, okay.
Yeah,
So
just to make sure we have time at the end.
We need a housing advocate in City Hall at the end, right? Like this, super important. These are the last two, so they'll be really fast. But this is somewhere that people can actually go to get answers to these things. And somebody embedded in City Hall who's actually understanding the issues of tenants. Tenants are not really a protected population in the city, despite being more than half of the population of the city. And we also know that people being displaced, again, this right to stability, is due to a lot of that financial hardship, the fact that there isn't rent stabilization. And so we believe that we can and need to set aside monies to keep people stable through City Hall. So that is why all of these deeply interconnected rights are here. Again, would love to have y'all come on board. We have a coalition forming that you should definitely be a part of. But there are definitely other ways to get involved as well. So please leave your contact info for me in the chat.
Thank you so much, Teresa. And I will definitely be sure to include your information too in the follow-up email so that folks can contact you that way too. And last we have Sumathy Kumar to talk about some policy advocacy at the state level.
Hey everybody. Hey everybody. Yeah, so my name is Sumathy. I'm the campaign organizer with Housing Justice for All, which is a statewide coalition. Push is on our steering committee. And I think I'm just gonna go through some of what we're gonna be fighting for in 2022. A lot of this builds off of what Teresa was saying and sort of mirrors a lot of it, but you know, the local legislation that we can pass is so important, but at the same time, like the statewide legislation is really like the thing that's gonna give us both the funding and the like overall protections that we need. So we are fighting for a whole host of things on the state level. I'm just gonna share my screen. The other thing I would say is that, you know, we're sort of in a planning phase right now and getting ready for session to start in January. So things are still getting worked out. The platform is still needs a name and all that stuff. But we know what we'll be fighting for. So I will go through that. And so context that we all know, we have a serious housing crisis. And I think what's really important to note is that we've had a year and a half or so of temporary measures that, you know, the housing movement has won, and they've been incredibly important and successful, ERAP, the Moratorium, but we need permanent solutions now to get us beyond where we were in February 2020, and move us a little bit past the pandemic and create permanent solutions. More context is that in 2022, the 5-year housing plan will be up. So over the last few years, Governor Cuomo has been putting out 5-year housing plans where he goes through the policies that he wants to put in place, the buildings that he wants to build, etc. And this year in 2022, we're up again. We have a new governor. So Kathy Hochul will be putting out her 5-year housing plan. And, you know, Governor Cuomo's last housing plan included huge tax breaks for developers and mechanisms that just caused the rampant gentrification that we're seeing across the state and a skyrocketing homelessness crisis. And the stuff, we have an opportunity to do something different this time. And so we want to offer our own solutions to what a 5-year housing plan could actually look like to bring us forward out of the pandemic and into a just recovery for New York State. And for us, that means two big things: stronger tenants' rights for everybody, and a deep public investment in our housing stock to end the homelessness crisis. So like Teresa mentioned, good cause eviction is our top priority in the state legislature next year. It is permanent eviction protections as opposed to the temporary eviction moratoriums we've had. And it's so important because on January 15th, the moratorium will likely expire. And unless we have something in place for the 1.6 million households that have no tenant protections, there will be a huge eviction crisis that we have to face. And so having good cause in place, which would give tenants the right to renew their lease, protect tenants from unconscionable rent increases, give them the right to organize and stay in their homes. This will mitigate any eviction crisis that might come from the ending of the moratorium, which we know has to happen eventually, unfortunately. And good cause, it would protect people all across the state. There are so many unregulated renters still in New York City who would benefit from it, but most renters who would be benefiting are upstate and in Western New York, where there are basically no tenant protections for folks right now. So huge priority for us, good cause eviction. Our other top priority is the Housing Access Voucher Program. This is a statewide rental subsidy for homeless and low-income New Yorkers to help them pay their rent. It's different than a lot of the other voucher programs that we have already in that it pays the fair market rate rent, which allows tenants to actually have more control over where they live, actually be able to live in places, because so often these vouchers that we get are so minuscule and so hard to access that it traps you either in like incredibly terrible conditions in your home, or just like makes it impossible for you to even find a place to live. So the Housing Access Voucher Program would pay fair market rate and be a permanent rental assistance program, as opposed to ERAP, which is of course temporary and emergency, because we see that, you know, there's about like 800,000 people right now who really express like little to no confidence that they can pay their rent going forward, even with the ERAP money, even, you know, if jobs come back, the rent is just too high and they need a voucher to help them pay the rent. The other great thing about the Housing Access Voucher Program is that unlike in Section 8, undocumented New Yorkers would be able to access it and be eligible for it. And so this is another top priority. We're hoping to get it passed in this year's state budget as part of this like longer package of long-term recovery. And then the final thing that we're really going to be pushing for next year is the elimination of this tax break for 21A on luxury development. This applies only to New York City, but it has cost billions of dollars to taxpayers in New York City and, you know, across the state, to basically, in exchange for unaffordable housing. And so it's up for renewal this year. And our hope is that we can kill it and eliminate it so that resources are actually distributed to pay for real affordable housing in our state. Adam just put in the chat for 85A, which is not quite a counterpart, but slightly a counterpart tax break upstate and outside of New York City. And we're starting to have that conversation about what it would take to eliminate that tax break as well, which is another like egregious example of just public giveaways of money to real estate developers who are not providing affordable housing and not evicting people and doing and contributing to like rampant gentrification. So those, along with, you know, a whole host of other things, because there's all of these other problems, like, you know, we recently had a ton of flooding in because of hurricanes, where people who lived in basement apartments were killed because of how unsafe those were. We're trying to legalize those kinds of apartments and bring them up to code. There's a lot of lead paint work that needs to happen, particularly upstate. There's a lot of different things that are playing around, but those are sort of our big priorities for next year. And I'll just go through the timeline a little bit. We're gonna launch our campaign on November 16th. We'll be launching both in New York City and Albany and in Western New York, probably in Buffalo, but Teresa will talk about that. So definitely come out to that when we have more information. We would love to have a big crowd out there. And then once we launch, we'll get started lobbying, get started having rallies, etc., building excitement. And then in January, session starts and things will get really intense. We're trying to pass this package of bills in the New York State budget. And the deadline for that is March 31st. So we're really looking at a 3-month intense budget campaign where we'll hopefully win a lot of things. And that's sort of what's coming. And I'll stop there and take questions and go from there.
Perfect. Thank you so much, Sumathy and Teresa, for giving us a sense of kind of the landscape of policy advocacy for tenants in the state and locally. Do we have any questions? Again, either in the chat or if you just want to unmute and ask a question or comment, any kind of discussion is welcome. Don't be shy. Okay. All right. Well, only have a couple more minutes here. I'll just add in a few things. I know we've had a lot of resources shared in the comments here, as well as from the presenters. So I'll try to corral all of that information into an email, as well as send you all the link to wherever this will be posted, probably somewhere on our website as a recording if folks want to share it with others. I'll also try to get the slides from the presenters if that's possible to share out as part of that email in case people want to use that as reference. Do we have any last words from any of our presenters on anything that's come up?
I guess I'll just add, again, if anybody needs rental assistance, a landlord or tenant, call 211. It's the easiest thing to remember, and it's the best way to connect to somebody who can help you.
I think so. It's a good takeaway. Any other last words?
I think I would like to thank everybody for being here. It was a ton of information. I want to thank everybody for the really important work that you're doing. As we work to change and expand these tenant protections, it's also so important that we know like all the agencies and all the work that you're doing to protect people on the ground and in the issues that they have right now. that's the world that I came from, frankly. And so I appreciate y'all so much. And I'm just gonna once again plug that, like, because that's the world you're in, you know how much change we need, and you should join us.
And I'll speak on behalf of us all. Please feel free to reach out if you have questions or concerns. It's an ever-changing landscape, as Adam referred to. So if we can provide you with any information or guidance, either for you or for people you're working with, please let us know.
Excellent. Well, thank you so much to all of our presenters for, putting these presentations together and giving all of this massive amount of information in a really digestible way. Really appreciate that. And to everybody who's joined us today. Thank you so much, and hope to see you at some of our future workshops as well.
Thank you.
Thanks, everybody.